the schedule as the merits session. What is the problem with that? This is not a merits question, right? What are we addressing in this room today?
Louder.
Yeah, we're going to do our best. Make sure we talk in the microphones because we're recording the session.
We're the substantive matters of the dispute.
Are we?
Anybody else? Give the microphone.
We're discussing the applicable law issues of the PSA.
Great.
Okay.
We will be referring to these as the applicable law issues or the CISG issues, not the merits issues. And it's going to be really important going forward that you understand that difference and you're able to be precise and careful with your language. As your job is language, precision is really important for your arguments. But this particular issue, you're going to have to be very careful to make sure you're not dealing with the merits issues, the substance of the dispute. You're dealing with the law applicable to those questions, and that's what we need to resolve, right? Who has, just out of curiosity, who thinks claimant's going to win on their argument? Raise your hands high. Who thinks respondent's going to win? Who didn't raise their hand? Here we go.
Why didn't you raise your hand?
Oh yeah, who do you here?
For example, for claimants, issue C is more stronger, but for respondents, issue D, the conflict of law, is stronger for me. So in my perspective, it's 50-50 chance.
Okay.
Yeah, as for me, it's the vice versa. Because like exclusion of the CISG is really hard for issue D for the respondent.
Okay.
And issue C is for claimant, like it's for for the.
So why are you unsure about who will win?
Because like they have drafted the problem like in the middle of everything. Like you can like argue this question issue C, like it is like it's not auction and so on and so forth. But the problem itself, it says it is like reverse tender process. Like yes, there is a like clear picture that to Article 2 is not applicable, but there is like things like you can go inside like and you won't stop like researching for the and for the issue D. I'm sorry, taking your time.
No, you're not too much. We are here for you guys. So.
So for issue D, explicit exclusion is not possible because explicit exclusion is only done to say like the CISG excluded, and implicit is really hard for the respondent to prove because there is only one thing to say that they meant by law of Equatoriane, saying that it was the domestic law from the model construction from 2022.
Okay.
Pass the microphone and see what do you think? Why is he wrong?
Yes, she was doing this when you were saying so. So we want to hear your point of view.
I would say I'm kind of the opposite. The explicit one is the most challenging one.
Microphone closer to.
For both. Based on our analysis on the derogation.
Well, let's hear her.
So based on our analysis on the conflicts of law principle, the implicit is basically the right one.
Great. So what I want you to realize is you do have a position, right? You actually think claimant's going to win, but when you're representing your clients, you've got a position, right? You aren't neutral. You aren't unsure. You need to help and guide the tribunal through what your argument is. And we're here to help you guys build some of that confidence in your position and be able to say, I think claimant's going to win. By definition, you said claimant's going to win on the application and then respondent's going to lose on its exclusion. You think claimant's going to win, right? We're not here to make that determination, but I want you to remember that you're here to persuade us, and telling us what these positions are going to be super important, and understanding your position. And the way that you get that confidence is knowing the facts, knowing the law, knowing your structure, and being able to communicate that really clearly. Because you did a great job. We know your position. Don't be afraid. Say what you think. That's great.
Your microphone should be closer.
Your microphone should be closer.
I know, I also do this,
Mhm.
but you told me that they need it for the recording.
Yes. Okay, so let's first just mark down what our issues are, so we're using the same basics here. What is the first part, issue C?
Where is the microphone?
If the CISG is applicable to the contract or not,
Which contract?
to the purchase and service agreement, PSA,
Mhm,
the abbreviation.
great. To PSA. And D, what's issue D?
If parties excluded the CISG,
What does it actually say? And the parties validly excluded the CISG. Okay, great.
Can I ask you something, well, before we start? Hearing Carl's lecture, learning more about the business, and having the discussion with Professor Brand in the morning, did your position about, who would win change? Did your structure of your argument change?
Mhm.
Did you start thinking of how would you approach addressing the issue C and D? No? Yes?
Do you have something? You look like you want to raise your hand. No?
Come on, this is just a discussion. We want to hear from you. Do you need microphone? No?
Okay,
Okay.
that's okay.
That's okay. Yeah.
What I hope is, oh yeah, so pass it down.
so I guess the way I'm thinking about the CISG's applicability, I remember we said in the oral pleadings we should bring up the termination.
Mhm.
So when it came to the technical session, I thought of using this against the respondent, which is that it wasn't only the claimant that had obligations that they had to uphold, so did you. So that's a way that I'm thinking of restructuring my argument.
Okay.
Who understood the nature of the project before walking in, or who didn't, I'm sorry, who did not understand the nature of the project before hearing Carl's demonstration? Who thinks they understand the project better after Carl's demonstration, whether you understood before or not? It's difficult, right? Yeah, Professor Rand did too. You must understand the project. This is one of the things that I think we're going to struggle with early on. Is we're law students reading the law, and we want to talk about Ingeborg Spencer. That's what we want to talk about, right? But Ingeborg Spencer is not what's happening here, right? It is a high-tech, big project, and you're doing something important for the sustainability of the hydrogen sector at the top of the technological scale. You're producing a new technology, and it's really important to know what that is, because the arbitrators are going to want to know. And the stakes of this dispute are going to be very important. Did someone have their hand raised? You always look like you're having your hand raised. So an important question that I want you all to be able to answer is, why does it matter whether the CISG applies? Why does it matter if you win?
Essentially, why we look at the CISG applying is because it goes down to the further merits. So what we understand is that the claimant's position is that the CISG should apply because it has a high threshold for fundamental breach, and their contention will be that we have not committed a fundamental breach, therefore you cannot terminate the contract for a cause.
What about the termination clause? Right? Because you can derogate from the CISG. They have a termination clause that has a standard different than fundamental breach, right? What does the termination clause say in the contract? Do y'all have it? Get your problems out. We're doing work today.
It's page 12, article 28.
Oh, here, you have this one. I'm gonna keep mine.
About the termination clause, it should be like a fundamental breach, and it will be like
What is the text of it? What does it actually say, the termination clause? Does anybody have it?
yeah, I have it. It's Article 28 of the contract,
What
which
page?
says page 12.
So something we're gonna do, and we're gonna make sure you do it throughout this, is anytime we're citing to the record, we're gonna have you do a record citation like you would in an oral argument. So what you would do is say, record page 12, the PSA, right? Article 28. You can see the page number, the name of the document, and then the pin site. Okay, go ahead.
And page 12 of the contract, PSA, Article 28, which is about the termination of the contract, first says, Both parties may terminate this agreement for causes in case of a failure of the other party to perform any of its obligation resulting from this agreement that amounts to a serious fundamental non-performance.
Great. So how is that different than fundamental breach in the CISG? Anybody?
Anyone has the CISG? Which article, which one?
And what does it say?
A breach of contract committed by one of the parties is fundamental if it results in such a detriment to the other party as substantially to deprive him of what he's entitled to expect under the contract, unless, okay.
So that's defining fundamentality, right? But we're talking about fundamental breach, which grants the parties certain remedies under the CISG. The termination clause is different than the CISG. It's a serious, fundamental non-performance, which is interesting. It doesn't say breach. I'm not sure if that's going to be different, but it is certainly different textually than in the CISG. How might that be different? The parties have derogated at pretty substantial cost from the CISG. So whether if the CISG applies, are we dealing with the fundamental breach within the CISG, or are we dealing with the contract provision in Article 28 in terms of dealing with whether there was breach sufficient to terminate, right?
I'm sorry, Robbie, but this just came to my mind. Did anyone compare the termination clause in RPSA with the UNIDRAW principles and how it is similar or different? There's similarity, okay.
In what way? Great.
Okay.
So it's got flavors of the domestic law, which is
Mhm.
interesting, right? Because now we're trying to figure out what the parties' intentions are here. So what about if the CISG doesn't apply? What happens? What's our standard for termination here?
PO2 states that the law of Equatoriana had adopted. Pause 1 second. No.
This will become muscle memory, and this is the time to learn.
Okay, so page 50 of PO1 states in paragraph 4 that Equatoriana has included a provision in Article 7.3 that governmental entities may always terminate contracts which have been concluded in the pursuance of a. Anyways, yeah.
So does that, is 7.3.8 the standard that we're going to apply in terms of the breach and the right to terminate the contract, or is the contract provision going to apply? The contract provision. Why?
Because primary source of law here will be contract law, and by the gap filling principles, if there's no terms or agreements between the parties, it would be referred to the law applicable to the contract.
So what you all seem to agree is it doesn't matter, right? You said
I would disagree.
Well, you say the CISG apply. If the CISG applies, the termination requirement is in the contract, right?
So,
And we said if the CISG does not apply, the termination standard is in the contract, right? So what's the difference?
no, that's what, it's not, it's what you said, it's going to be domestic law.
Oh, I thought you said it was in the contract.
So because in the termination there is no clause for the what is the termination can be when termination may be preceded by the parties, and it says like there is no right for the customers, and it doesn't define the failure of the party on the when performing its obligations. So we would refer to the domestic law to interpret the first part of it, and the second part of it terminates the right itself.
Wait, do you have another microphone? Oh, yeah. What? Can you say that one more time? Yeah. It takes a
Okay,
second.
yeah. So here it defines that when termination may happen
Okay.
in the first part.
This is Article 28 of the contract.
Yeah, 24, page 14 of the problem, Article 28, Part 1, defines when termination may happen by the parties. But it says, again, like when there is, when like respondent as a customer cannot terminate. And it says like we are not using the 7.3.
Mhm.
The fact that
The contract says that.
yes, it's derogating, they're excluding it.
Right.
So that's why we would refer to domestic law for the part two, where
So I think those positions are contrary, right? So what we're saying is the contract provision excludes from its application the application of 7.3.8. So you cannot rely on it, right? So that's what I was saying. That's the point I was making before. If the CISG applies, Article 6 permits derogation from the CISG, which the parties did in Article 28 for determining that termination. If the CISG does not apply, the parties also in that termination clause derogated from 7.3.8, and the Union principles would allow for them to have party autonomy and make those determinations. So wouldn't that termination clause still apply? Does anyone think it wouldn't?
no.
Banker?
Yes. According to record page 31, exhibit R2, it was stated that the termination for the or excluding the right to terminate for convenience was done because the respondent thought that 50% of the supply was from local content.
Mhm.
And under the unilateral principles, such offer is considered to be bad faith, and you can so we can rely on Article 7.3 because it was built on something that was not done.
So that's another argument why 7.3.8 does not apply.
Does apply.
Does apply.
Yeah, it's in favor for the respondent.
Can you restate that position one more time?
According to the unilateral principles, it is stated that when an offer does not have a truth, or it is considered to be bad faith.
Oh, so you're saying that
Given in a bad faith?
Yeah.
you're saying that the termination clause itself is invalid,
Yeah.
even though the parties agreed to
Yeah.
it, it's
Yeah.
invalid
Yeah,
itself.
because it was built on an offer that didn't happen, which was
Interesting.
50% local content.
Okay, so interesting. We need to get a good answer on that, right? Because you can contract for these kinds of things. Why would it matter which of these two laws applies if the parties can contract away from the applicable law and to decide that this is what termination is valid, right? You're going to need a good answer to this question, and we're going to try to get there to try to understand that argument, but you're going to need to know why it matters which law applies. Because every arbitrator, that should be their first question. If we can't answer that question, we're not going to be able to have this kind of a dispute, right? What's the point of arguing about which of these two laws applies if the outcomes don't change, right? What are we arguing about?
And today, because we're discussing a claimant, so let's go back to Article 28 of the PSA, and it says a termination fundamental, do we think here this is, the respondent could win if this Article 28(1) is applied? Do we think there was a fundamental breach as defined under the contract? My position is no. It will be really hard to prove that not, submitting the plans on time, being late for 28 days, that amounts to fundamental. I mean, it will be really hard to prove that it is, which means that what has happened, that the respondent has relied on a termination for convenience, okay? We want to, as a claimant, stick to the contract, okay? We want to, for this deviation to apply, okay? So that is the focus on, and that's what we need to have in mind, 28(1) is not the problematic for us. What happens if we have to discuss the 28.2 and termination for convenience. You have a question or a comment? Okay. So
Okay,
having that
those
in
things
mind.
are important, right? I want to keep that in mind. I think we need to get to that answer and we need to get it concise for ourselves, no matter which side we're on. If you're claimant, you want to know why it matters that the CISG applies. If you're the respondent, you want to know why it matters that it doesn't. You may not be able to get a definitive answer because we don't know all of the facts and all of the information we need to know whether that termination, the right to termination in the domestic law is an overriding mandatory law that at any time could be applied, and or whether the fact that they negotiated that termination provision should even still override that domestic law in any other circumstance. We don't know that. If you're claimant, you never want to be in that world, right? That's probably why you want the CISG to apply. You don't want to deal with this applicable domestic law outside of the CISG. You want to avoid it at all costs. That's your job. If you're in the Equatoriana law, now you have to deal with this question, right? So you can understand how to apply, how to get the tribunal to write an award that follows the path away from dealing with this giant, hairy, scary thing, which is they have a right to terminate under their domestic law. You want to get as far away from that as possible, right? And we have to understand why.
Here's the question that we all know there is two like sources that there is like maybe right gives right to respondent to terminate the contract. Which first is contract law of the Equatoriana. Second is civil law of the Equatoriana. So what you are basically saying that we should avoid both of them.
If you're a claimant, you want to get out of that universe. There's new ways to terminate, right? You want to make sure, that's why you're saying the CISG applies. You want to be able to get out of there and not even have to answer that question. The hard part here is when I asked you whether the difference exists, you may not know. You may need to do additional research to determine whether the outcome will be different if different laws apply. And you need to know that, because no arbitrator will seek confidence in writing an award in your favor by saying, I don't know if there's a difference in the applicable law. They're going to say, then what are we doing here? Right? You need to be able to do that to make them want to write an award in your favor.
And so what is Robbie saying, you're already have to think what arbitrator will put in a award, but realistically also you will get a question from the arbitrator. Why is this important for you? Why it's important that the CISG applies? Like why shouldn't we just rely on, UNIDROIT principles that are the Equatorian contract law? What's the difference? So already for just answering a simple question from the arbitrator, you truly need to know what will be the difference. So you need to dig deeper, okay? So it will be the question why, because they will want to know to see if what they were already thinking before they came and listened to you, if it's gonna stay, how the award, would look like at the end. So do you want to structure it a little bit?
Go ahead.
So, but I want to ask you, how should we do it? So I think we're discussing a big question, but is this what you're going to start with? How are you going to structure your argument? What will be the first position?
Well, first, let's do this a little bit more, setting the stage. What is your job here? Now we're in the oral argument stage. What is your responsibility as the lawyer for claimant? What is your job? What is your mission? What have you been sent to do? Yeah, y'all have a microphone somewhere, right? Yeah.
As of now, it's just to say that the CISG applies and that we haven't excluded it.
What is your greater mission? What were you hired for?
To say that because the CISG applies, there was no fundamental breach.
It's a little bit bigger, a little bit bigger. What does your client want?
To see that in the tribunal award, saying that the CISG
They
applicable.
want an award written in your favor.
Yeah.
This is what you are hired to procure on behalf of your client. This is your mission. You are to seek out this arbitral award.
Sorry. I would just say that it's also that the claimant wants to continue this project. So it's not just
Their
any
interest,
kind
of
of
course.
award, but it is that there is a specific performance, so they continue with the project. It's of a big importance for them, okay? That will be a really important thing to have in mind, especially when mediating and trying to settle the agreement. But I think it's also important when we are discussing, what is the goal of this arbitration at the end.
Right. When you're sitting in front of the arbitrators and giving them your oral argumentation, your job is to fulfill claimant's interest in continuing the dispute, but your relationship between you and the arbitrators is getting the arbitrators the instructions to draft an award in your favor that you can then take and go get enforced. That's what you want. This is the golden ticket that you're trying to use. So when you're building your argument, you need to keep this in mind. The arbitrators will use what you give to them to draft the award. This is what they're looking for. When you're doing real arbitrations, you're going to finish your hearings and then you write post-hearing briefs for the tribunal to say, this is the award you should write. And they'll often take huge sections of that to draft their award based on what they believe or disbelieve. You're quite literally helping them write an award in your favor. And I want you to imagine that you're doing that when you're in front of the arbitrators, you're guiding them through that process. and they will feel most comfortable writing an award that draws the straightest and shortest line between the issue and the conclusion. That's what you're trying to do. They'll be very satisfied and feel comfortable writing an award that doesn't run through circuitous new ideas, doesn't need to change the law, doesn't need to advance things. You want to be able to say, this is a comfortable, direct, clear line to the application of the law that we want. And here's how you can write an award, Madam Arbitrator. That's how you can do, that's sort of your mission here. So when we're talking about how the CISG applies, what do we start with? What happens here? What's our first argument for its application? Get the microphone here.
And there is also a hand there. I will give.
So for the CSG applies to the PSA, the first argument that we could start is the applicability of Article 1(1)(a). And then following, should I continue with the
Sure,
following?
yeah.
Article 3(2) of the CSG,
Well, can you tell me why does 1(1)(a) go first?
because it's the contracting states.
Right. What else? What other elements are in Article 1(1)(a)? Yeah. What are the other elements? Who's got it?
It's an international sale of goods with place of business in different contracting states.
Mhm.
So the claimant's perspective will be to establish that it is a sale of goods. It is international because the parties are in different contracting states.
Right. So why are we starting in Article 1? Why is that where we start? Because what you want is never to get to the CISG at all.
Does it not just mean that it works as a default law?
Yeah, it applies as a matter of substantive law. But what I mean to say is when you're making your arguments, you need to think about what wins you the case in the first place, right? And here, the Article 1(1)(a) arguments about whether it's the place of business are in different states and these things is certainly an argument, but don't we want it to not even be a sale of goods, right? Aren't we dealing with really the Article 3 argument? We're not in the universe of the CISG. That would be the argument that gets you, who cares about the place of business? Who cares about anything else? We are not in the world of the sale of goods contract. So the argument that wins you completely is getting rid of even being in a sale of goods contract, right? I think, oh, I'm sorry. Yeah, either way, you need to address that first. Yeah, stop me if I'm arguing the other side. That'll happen all the time. But do you understand the difference there, right? For example, in the United States, we have tort law and we have like contract law. And oftentimes parties will bring disputes in tort and try to claim it's a contract dispute for lots of reasons, mostly because they wouldn't have jurisdiction to deal with the tort claims. They only could deal with the contract claims, often kicks out things that are outside the contract, right? So if you can argue, you don't want to argue that the tort claim is, premature, or you don't want to argue it's whatever. What you want to say is it's not a contract claim and they cannot bring it, right? It's completely outside the scope of the law that we're applying here. For the CISG, it's the same thing. We are outside the scope of the application of CISG because we're not dealing with a sale of goods at all. Oh, I'm sorry. I'm sorry.
No, it's okay.
So let me clarify. So you are, yes, you are proving the point that Article 1 and 2 are met, the criteria are met, and it's taken for granted.
No, the opposite. So if, like, for example, if you did Article 2, you would be taking for granted that there is a sale of goods, but have not proven it yet, right? So Article 2 is an exclusion of the CISG where the CISG is covered in its scope. So you first need to demonstrate that there is a sale of goods. That we're in the world of the CISG at all needs to be demonstrated first. Then we can talk about the internationality requirement that is met. You see what I'm saying? That's when you get to 1(1)(a), and all the other elements of 1(1)(a) is because you've demonstrated that there's a sale of goods here. Right, yeah.
Determines the sales of goods between the parties who have a place of business in different contracting states. Oh God. So it's a sale of goods. It's between the parties who are in a different states, and those states are contracting states, okay? And this is what you have to present first to show that the CISG applies, because the main requirement for the scope of application, Article 11A, is met. Listen, we already know that there are a potential issue, and the main thing you will here have to address and understand well, and that's why it's great that you had Kyle to discuss. Carl, sorry, Carl, if you're listening. So when you had Carl discussing and explaining the business, you understand what were the goods that were actually being sold, because we can also not disregard the fact that it is mixed. I mean, it's in the name. Purchase and service agreement, okay? But here you will have to focus on explaining the goods. You would address that it's between the contracting states, between the parties in different states and contracting states. And you probably already know the issue regarding the subsidiary, okay? That's not something that you would lose time on presenting. This is something that you answer only if you're asked, okay? Because you want to emphasize this, the requirements are met. It's a sales of goods, okay?
Yeah. Well, and you see the logic here, right? If you start with internationality, the entire time inside the arbitrator's argument in mind is going to say, but is it even a sale of goods, right? We don't need to determine the internationality requirement if we don't have a sale of goods. We have to get in that scope, and we have to know whether we're in that universe first. So you need to demonstrate that we've got a sale of goods contract. Then you can satisfy that internationality requirement. And then members of the tribunal, the CISG applies autonomously under 11A, rather than trying to deal with any of the other elements. You're dealing with whether we have a sale of goods first. Does that make sense? Great. What comes second? Yeah.
So the second one would be the CSG according to Article 3.2, which states this convention does not apply to contracts in which preponderant part of the obligations consist in the supply of labors or other service.
Good. That's the how we determine whether there's a sale of goods, right? Is that test in Article 3.2. Does anyone have arguments under 3.1? Do you think respondent's going to make an argument under 3.1? Anybody?
Respondent has, according to what Carl said, the green site field and other permits and licenses, when you add them together, they can be substantial contributions.
But
Wait.
from the claimant point of view, do you have an argument for 3.1?
3.1 would probably need to be satisfied if someone challenges it, right? Go ahead.
I think my understanding is that even according to Schwenzer, land is not a substantial obligation, especially because it's a construction project. Land is, lack of better word, like a bare minimum requirement that the buyer gives. So I don't think that would be the most impactful. But with what Carl brought up today, and I was also thrown off, is the issuance of permits. So we're not sure to what extent Equitrans Rent Power is involved in the issuance of these permits, just that they're giving it to them. And is it possible that the claimants could have got that? Not sure. So permits is...
There is that it says that it was really important that respondent was able to get them the license. It's
Right, so-
in the beginning.
But what I want to highlight here is there's how many arguments we've got, right? So we have under Article 3.1 about whether the substantial material was provided by the customer, right? By the buyer. I am unsure. I haven't really focused on respondent's position here. I cannot imagine that argument's going to win, right? Because the land itself, we know, according to Her Highness Ingeborg Schwenzer, is not material that is for the sale of goods, right?
Good that Schwenzer said that, but if you have to think of it on behalf of the respondent, what would you look at? I'm sorry. So Schwenzer had this comment based on what? Probably some case law, okay? So I would go and check the case law, and did it at all discuss and dealt with this kind of investment state situation? Because it's completely different when you provide the land for the simple house to be built, you know, it's a small piece of it, or a land that is given by the government for the production of and construction of the plant. So I think you can make some kind of distinction between what, yes, Her Highness Schwenzer has said,
Yes.
and to say, okay, in those cases, probably land was not material. However, in this case, you know, we would focus on showing, yes, it is. So don't, if it is a point and only point you can make regarding the Article 3.1, see why that was the commentary by Schwenzer. Why did she say that? There is a reason for it, and it's a good thing for a claimant to know.
I just thought about
Oh,
something.
yeah.
Who goes first in this argument? Let's think about the order of the argument. So the first thing you're going to do when you're doing an argument is you're going to approach the opposing counsel and you're going to reach an agreement on the order of presentation to the tribunal. Who has an idea of what the order of presentation should be? And for all four.
Sure. Based on the burden of proof under the CISG, the one that's saying that the CISG does not apply must go first, and that's under Article 1, 2, and 3.
So the respondent is probably going to be going first, right? The CSU didn't say that the respondent goes first. It says they bear the burden, right? And the person that bears the burden of meeting the challenge generally needs to make their presentation first. So what I'm just realizing is we probably should have started with respondent, right?
Today.
Yeah, entirely, because respondent is also making the jurisdictional challenge.
Yes.
So they're probably going to be going first too, right? But we get to live in a world where we're claimant first, and we're going to learn about respondent tomorrow. So that's how it's going to go. But what I want you to think about,
Robbie, and I'm so sorry to interrupt you. When we started this discussion today, I was like, why we are starting with the C?
you had said something.
No, I wanted to later on, ask the question, do you want to stick with this order, or is it more important to be addressed? Did we even agree for the CSG to apply? Okay, because parties should also agree for the CSG to be applicable. Okay, and only if yes, can it actually be applicable to it? I don't know. It just crossed my mind. Me and my team didn't discuss that.
Also,
but now I was thinking,
who should go first, the applicable law issues or the procedure? Do we have opinions on that?
I think the procedure should definitely start first
Why?
because you're talking about mediation and changing the dispute resolution mechanism. So a result of the proceedings, if we were to continue with arbitration, no, actually, if we continue, whatever the arbitral tribunal decides, whether it be a preliminary award or a final award, is should we continue arbitration or not?
What arguments are they making in that in the procedural section for the mandatoriness or applicability, enforceability of that mediation condition? What are they doing? What do they need to know?
Could you
What's their argument? How is their argument? What do they need to do?
Where's the second mic?
Do they have jurisdiction or not?
When they're doing that argument, what are we working with, right?
If I remember correctly, they're saying that they never intended to go to mediation. Can I add one more thing? And I think that's why you asked the question of who would go first, because if the CISG does apply, they would use Article 8 to determine that intent.
Right. They're talking about party intent, and the CISG or the law applicable to that agreement is what we're going to use to determine party intent. So should we be talking about the CISG first, perhaps, before we get to that mediation requirement? Because when they're doing their argument and they're going to be talking about jurisdiction and someone says, what was the intent of the parties? What law are you going to say, right? If you're the claimant, you're going to say CISG Article 8 says this, this, and this, and everyone's going to be able to feel fat and happy, but you're not going first. They're going first, right? So they're going to want to say Equatoriana law requires an intent be determined in this manner, right? So you're already fighting an uphill battle dealing with that. And luckily they go first, so you can make them have to confuse the tribunal about what law they're trying to apply, right? Or maybe the tribunal is going to make them deal with CISG because they're going to presume it applies till they determine otherwise. Who knows? But we don't know what law applies to interpretation yet. So maybe we should be talking about this first. Not really sure. And I think there's going to be some disagreements about that. And when we're doing our oral arguments and when you're preparing for this, I think you should have a position and be willing fully to compromise that position and go in either direction. You're going to have to do both because you don't know what your other opposing counsel is going to be like. And they might be shocked by the concept of whichever one you like better, right? Because I think there's going to be some disagreement about what to do.
What we were trying to tell you and suggest, practice a lot and practice different orders, okay? Just to feel comfortable with it. And also, I think switching order a little bit makes you think of, does all of your arguments make sense,
Yeah. So, and you're responsive the whole time, right? You're not giving an affirmative argument. So when we're thinking about developing our strategy as the claimant, either in the procedural positions or in the applicable law positions, we need to know all of the arguments, because you don't know what kind of cuckoo students are on the other side, and they're going to bring up all kinds of weird stuff, right? And you need to respond to their argument. So you're going to have to be more prepared being on the responsive side, which actually makes it much more fun. But the reason why I bring this up is because the Article 3.1 argument probably is not that strong for the respondent. There are lots of arguments that the parties are going to want to bring up that are kind of not that great. What are other arguments related to the applicability of CISG that might be brought up but aren't that strong?
There is a microphone next to you.
Oh, sorry.
No, it's okay.
In my opinion, I would say Article 2B regarding the reverse auction. I don't see that a very strong point for the claimant.
Anything else?
For the
Or for the respondent, you're saying?
For the respondent.
Yes.
Oh, for the respondent. Because I was like, claimant?
Yeah.
So for claimant, we have to satisfy all three elements of applicability, but for respondent, can't we just address one, right? Okay.
That's an important point. That when you're building out your strategy, first of all, you have to work with your co-counsel, which is what I was trying to demonstrate before. Y'all need to be on the same page, demonstrate your voice, a single voice on the law applicable and that analysis for interpretation. But you also need to be able to understand that a respondent only needs to win on one thing. And if they're smart, they're not going after the auction, right? That's not what they're going to be running after. But if they like to talk fast or they don't have that intuition to realize they can be lethal and surgical, they don't have to sort of hit everything, they're going to come at you with an auction argument. So we're going to have that in our pocket. We're going to have to know about that exclusion.
You can also be asked by arbitrator, even if the respondent, it goes first and they don't mention anything, but arbitrator can, make a question saying, but wait a second, isn't this like an auction? And isn't that excluded under the CSG? So you still have to have it prepared, but it's going to be something that you have an answer to, not something that you go and argue as a claimant, because why would you?
So I had a question in regards to the respondent. Would it be, because the numbers are in favor of the claimant, like the preponderant test is better for the claimant. So as the respondent, would it be smart for me to bring up Article 3.2?
Well, let's say this. Right now, we are partisan. Respondent is unreasonable. They've wildly decided against law to terminate the contract. They're crazy people over there. We're partisan and on our side, right?
Yeah.
So I don't really care, right? If you think it's a good, if we want to know if it's a good idea for them to do it, we need to know whether we should be prepared for that kind of argument, right? It's sort of a different approach when you're thinking about those things. Yeah, I know. It's now it's becoming uncomfortable. So the preponderant part test. Who thinks that the preponderant part test should be this quantitative economic test? For claimant. We're a claimant. That's all.
For claimant, yeah.
Claimant is the prettiest girl in the school.
Okay, amazing. So yes, it should be the preponderant test to quantify or qualify what are the goods value and what are the service value in this contract.
What is there another test?
It's the economic intentions, intentions of the parties we can apply into the why. Okay, so according to the CSG opinion number 4, we found that there is this economic value test that we could compare the value of the goods and the service. So we looked into the Exhibit C5, page 17, paragraph 11, that you can compare how it's going to be distributed. That's
well, I guess what I'm getting at is what your job here. Again, your job is to get the arbitrator to write an award in your favor. The arbitrator is going to want to know what test should apply, and everybody knows there are at least 2, right? So you need to tell me why that one applies. And it's not because I win if it does, right? Why does a hard line just balance out the scale numbers apply in the context of a multi-$100 million long-term, super complex construction contract? Do we think that blunt of an instrument is going to work?
Okay, so if I had to think from the claimant's perspective,
Which you do.
Okay, so now that I am the claimant, why I think the economic test should apply, not just that it's in our favor. Firstly, this test, according to the facts, was shared with the respondents. So the respondents knew about this as well. So even though it doesn't talk about intent per se, the fact that the respondent knew should play a role into it. And
Why?
the fact,
Wait, why is that?
because I think that the fact that they shared it with the respondent never gave any objection or anything. They knew that the goods were
Does
in
the
a
CISG
majority
Advisory Council opinion or any case law say that knowledge of the existence of a legal test means that that test should be applied?
No, I don't think so.
Probably not, right?
Yeah.
Yeah. So what I'm getting at is, we'll talk about this a little bit tomorrow morning when you're thinking about your arguments. Your job is to create and rigorously apply legal tests and legal standards. You need to figure out what the standard is for determining this kind of test. What are the circumstances under which that will be applied? Develop a rule that says under the CISG, there are two tests, the quantitative test and the economic value test, or whatever it's called. To determine whether these tests should apply deals with these kinds of factors. What are these factors? Is it complexity? Is it size? Is it party intention? Is it maybe knowledge of the existence of a test? Probably not, but it might be, right? We have to know what these are and develop a rule and then rigorously apply it. That's what we got to figure out, is what rule are we trying to get the tribunal to apply. And I want y'all to remember that your lawyers, first of all, and you need to think and argue and persuade like lawyers, but also that your job is not to presume that they understand what's in your mind, right? To you, something makes complete sense, right? You've done all this research, you've done all of this writing, you've spent all this time on the record, but you need to get it out of your brain and into mine as the arbitrator, and you cannot presume that what you're saying makes sense to me. Surprisingly, what you'll find is arbitrators are super easy to confuse. We're actually not, we're a bright bunch of people, but we get very confused very fast. And it's because you're making super complex arguments. You have to do lots of different elements, and it's a big universe, and you put it down to 14 minutes, right? So you've got to rigorously determine what those rules are and never skip a step. At any step, you should say, what law applies to this question? What test is going to apply to that question? How do I then apply that test to this question and show the tribunal that's how it's supposed to go? That's what we're always going to want to know, right? Okay. What other arguments are there that crazy respondent might bring up in terms of applicability of the CISG?
The place of business, if claimants have more than one place of business under Article 10A.
Place of business. So we've already got a big list, right? We had at least 4 big arguments that are coming up. So when you're making your oral argument, you're going to do a couple of things. You have to respond, right? Already in our first section, we have 4 potential options. If when respondent comes out and says the CISG does not apply, and I'll show that in 4 parts, you're going to say, woof, they're never going to finish that, right? That's crazy. But if they do, you've got to say, mirroring respondent's position, we will demonstrate that the CISG does apply, and it will be in those same 4 parts. We'll address each of those 4 arguments, right? You don't need to address all of these if they don't. You should focus on the ones that are strongest for you. If they don't deal with the auction, you don't need to deal with the auction. There's no need to bring up an argument that you need to beat down unless they do. Do you understand? So these will come in the form of questions. These are going to be question arguments. Your auction arguments, your the Article 3.1 argument, for example, these are going to live in question responses from the tribunal or in being directly responsive if claimant brings it up. I'm sorry, respondent brings it up. One day I'm going to remember who I am. Does that make sense?
So you're technically saying that if the respondent does not bring about the reverse auction, we shouldn't even touch on the subject.
Why would you, right? Because if what you're trying to say is the CISG applies, why would you would be like saying also the CISG is not a auction, and then the tribunal is going to say, well, wait, is it? And now you've introduced into their mind that it might be an auction. If that's not addressed, don't bring it up until they ask the question.
Article 2, 3, 4, 5, and 6 are when the CSG does not apply, okay? And if you're saying it does apply because Article 1A requirements are met, why would we even go and discuss why would not apply? You know,
Mhm.
that's the job of the respondent who is saying the CSG is not applicable to it. So we should respond to what they have said. If the respondent will go first, okay? Or yes, of course, let's say you go first because you have not decided to change the order, like, and the other side is insisting, no, claimant should go first. Again, you're starting with 1A. And then you would have a transition, and there are no grounds for the exclusion of the CISG. For example, Article, 3, again, it's more important to address than the reverse auction. What's going to happen that you will get probably a question about it, and you should be ready to respond to it, and respond it in a simple short paragraph, basically.
Mhm.
That's what you're going to have, explain if you're asked about the reverse auction, why it is auction, why it's not an auction under the Article 2.
That should be a nice heavy pitch.
Yeah.
Not get hold of you.
Yes. Can we just go back to the goods? What are the goods being sold here? Yes?
Here, can I steal?
The 100 MW plant, and then also the electrolyzer stacks.
Do y'all know what the MW stands for?
Megawatt.
Okay, I just want to make sure, because I heard like 3 or 4 people say MW. Just want to make sure we know what that meant. Okay.
Okay, so the plant and electrolyze. Anything else?
So they are doing everything, construction.
Those ain't no
uh,
goods.
No, not goods. But they provide PCA and everything.
Correct.
What is making claimant? Why did respondent choose claimant during the tender process?
Oh, wait, and can we go in the back? Actually, he talks too much. Yeah.
It was dependent on the local content requirement because the respondent wanted to meet a certain threshold for local content.
They already had the transformer, suitable transformer. They had the lowest price bid in the reverse auction because they didn't.
Am I audible? The other parties, that was like an innovative idea that they were just initially start to doing that. So the knowledge and services that the claimant could like fulfill was also an important option for choosing. I'd say the knowledge.
The electrolyzer I'm sorry, isn't the electrolyzer that claimant is selling something really specific? Doesn't imply some.
PEM electrolyzer. I don't know the full name of it, to be honest.
Yeah, it was green and it doesn't like emit CO2. That's why. Eco-friendly, you mean?
It's a unique. No, it's patented.
Yeah, by the
Is it truly only goods? Okay, I know we're discussing from the point of the claimant, we are claiming today, but we have to understand that it's not only the goods that are selling. That's one of those goods, the electrolyzer, are connected to this patentable innovation that made them, so unique. And that's why, that's their whole business, This is something that maybe can be raised as a question, and you have to be ready to address it as a claimant. You will not initiate the discussion yourself, but it is important, part of the goods that are being sold. So something to be aware, because if this is a patent, that's what? Tangible good. Okay? Going back again, that we have a mixed contract. Services, that doesn't make it mixed contract. I made a mistake. I'm sorry. We have tangible, intangible goods. Okay? But mixed contract is for something else.
Which parts of the contract are relevant to the sale of goods analysis? So we need to determine whether we have a sale of goods, right? And we're trying to say yes. Does all of the contract apply?
I would say like referring to Exhibit C5 as again, page 17, paragraph 11. That's one of the past exhibits that we can refer to determine the preponderant part.
What is it? Exhibit C5.
So let me just go through. So basically it breaks down like the total investment from green hydrogen and voltage transformer and the electrolyzers and that exactly the name of it.
Yeah.
It's the witness statement from Bo Cavendish.
Great. But what I'm asking a little bit of a different question. The construction contracts are very complex, right? This is what we learned today. This contract is also pretty complex. We have the initial purchase of the 100 megawatt plant, and then we have two options, right? Which parts, and there may be other components that we need to consider. Which of those components are applicable to our interpretation of whether we have a sale of goods? Oh, is it all of it? Or only some of it?
I think from the claimant's perspective, it's a delivery of the plant and all the services attached with it. So that's the EPC work plus the ancillary maintenance and training services. So they're integrated into the contract under Article 2 of the PSA, but I don't think the final price reflects the options. That's an extra 100 million, extra 60 million.
So if you're the claimant, are you trying to say that only the pre-option versions of the contract are the ones that we're analyzing for the purposes of whether there's a sale of goods? Do we think? What about the other two? Oh, does anyone think we should use the options? Or are you unsure? Do you know the effect? What happens if you only look at the main part of the contract versus actually looking at the options? Does that change our percentage analysis of whether it's a sale of goods, for example, under that quantitative test?
So here we know that in the 100 megawatt option itself, we know that its preponderant part is source of goods, and the first option, like doubling the quantity of the megawatts, is works for us. But we don't know about the ammonia option.
Great. So we think that using at least the first option will be helpful for us, right? We think that. Do we know the number differences here? We need to know that number, and we need to know it very, very well. This is a complex argument that y'all are making, and we have at least 3 different components of the contract, right? We have the main 100 megawatt electrolyzers. We have option 1, which is doubling, right? And then we have option 2, which is the ammonia. Right? So it's going to matter what parts we use here. We need to know how to determine that. Do we have an analysis on how to determine which parts of the contract are being used? They've certainly agreed to them as options. We don't know, we know that they were intending always to exercise this option, but had not exercised it. Is that correct? That it has not been exercised, or that it has? The ammonia, right? So we don't, but is intent to in the future exercise an option that has not been exercised affect that analysis, right? It might, and we need to figure this out. We need to know, this is what I mean about developing a rule and a test. When you say, is there a sale of goods, we look at this contract and you need to say, when looking at this agreement, we determine whether there's a sale of goods by looking at the entirety of the contract, not just those parts that have been performed, right? There's a part or all rights that have been exercised within that contract, not just the ones that have actually been exercised, just the all available, or just the ones that have been exercised. We need to figure out an answer to this. And when you're giving your argument, you need to develop that rule for the tribunal. You also, I don't know how I feel about this at the end of the day. I don't know how other teams are going to react. I would think about making charts for yourselves and seeing if you can convince the other side to let the tribunal have it. You can do that under the Bismuth rules. You should 100% read all the Bismuth rules. You must read the rules. You can have exhibits if the other side and the tribunal agrees. This is a circumstance where there are tons of numbers, right? We're dealing with the transformers and the electrolyzers. For the sake of determining the goods, are we also dealing with the, what is it called? The other stuff around the electrolyzers, right? Because they have like the hookups and for the trafo part, right? Does the trafo count as part of the sale of goods? If we're determining these are the goods, is all the ancillary stuff that we use to install them part of that analysis, right? Do we need to include that? Are we sure, right? Does that count as a good or is it a service if it's not the actual goods that come with it? You see what I'm saying? We need to know all of these answers and figure out how to make that interpretation and apply that rule. Determine a rule and apply it rigorously for that purpose.
Robert, just to add, so it would be great if you have charts, but maybe it's not going to happen and like you spend time preparing and tribunal says no, then it's really important that you're good with the record. And then when you are preparing your argument, you'll be like, if I can lead the tribunal to the record, and maybe you want to show them the contract first and say, this is what they have agreed to. And if you look at the page 17 and explains to you, gives you more detail what is included in a plant. You know, you have electrolyzers and then you have the APC work. You can use the record for your advantage as well. You know, don't just think it has to be now charts, because that would be really cool if we can do that.
I know. Every once in a while, there's like really complex things that I wish students would try it. I've never seen anybody do it. I encourage you to try. But it's really difficult, and math will freak out your arbitrator. Math is really difficult. And
But also convince them if you can show them easily.
Yes, good direct math is really persuasive, right?
Mhm.
So for example, if you can say, let me take you to page 17, and here are the three important numbers. It's that third one from the top in the second row, the fifth one from the top in the fourth row, and the seventh one from the top in the fifth row, right? And say these three numbers, when multiplied, equal this for this reason. You see what I'm saying? You have to walk them through your math. Don't just say the total percentage of the contract, if you have this and this, equals this number, because I guarantee you someone's going to have a different one, right? You've got to be able to walk through that math and do it in a really careful, detailed way. It's going to be a big burden for the people in this room and in the respondents room.
Yeah, and also not only to answer to the tribunal, but you have to be careful listening to the respondent and vice versa. Sometimes, I'm going to be honest, my brain still, for certain things, works in creation. Numbers is one of them. So I have to be really like mindful to hear, you know, and to have the, you know, visual of the number. So something to be aware of it. Numbers are going to be important, especially for this part, you know, discussing the goods and everything.
Yes. So we just spent a lot of time in the contract to understand the sale of goods part. For the purposes of time, we're into 2:30, right? Is that what the schedule says?
Can we just
I want to
sum
do a little
up?
bit
Yeah.
on the internationality just for a second too. You're going to have the same problem for internationality. Does the contracts, is the internationality of the contract for all three of those components, might they be different for a different reason? It's a completely different analysis, right? Because Article 10 says what? For determining if there's multiple places of business, what do you need to know?
It's a relevant place of business which has the closest relationship to the contract and its performance, and keeping in regard the circumstances known by the party before at the time of conclusion of the contract.
Very nice.
Yes.
Yes, the knowledge of the parties, which is, remember your favorite thing, the knowledge of the parties at the time of the conclusion of the contract, right? If their knowledge is that they plan to exercise an option, but they haven't exercised the option, is that enough? If there's a future intent to do that, or if claimant has a future intent to purchase and acquire a subsidiary, but hasn't done so yet, nor has it communicated with the other side, do both parties have to know at the time of the conclusion of the contract? All of these answers need to be developed in that test, and it's going to be, you're going to have to know all the components of the contract without freaking out the arbitrators, because on one analysis you're going to be dealing with a whole kind of structure, and then you're going to say, okay, let's do it again, and now we're going to say these parts of the contract apply to the purpose of the internationality, and that's why your precision and clarity is going to be super important for this.
I think as a claimant, you should just focus on this part, you know, at the moment of the conclusion of the contract. But if you're asked, And if you have a prepared arbitrator, he can take you or she through this, all of the parts. And for that, you need to have an answer. But if you are just presenting, and if the question like, is this an international contract? You have to say, yes, it is, at the moment, because the Article 10 tells us that. You don't want to open up for the discussion of this unless you're asked, and if the respondent raises that, then you have to address it, okay?
Right, and I also think it goes to the end, like introducing problems where there may not be,
Yeah.
right? So what you can do as a matter of simplification, you can say, no matter whether we include all of the options or just the main contract, it is still an internationality requirement, right? Or no matter whether we go and include the subsequent acquisition requirement, if we import that knowledge onto the parties, no matter what, we still win. Or if you know you lose under one, don't lie, right? You don't want to do that. But if you say, then you can say only if that part is included or excluded from the analysis, do we lose? And under the law, it should be. You see what I'm saying? You can make it simpler for the tribunal rather than going through every little step. You can find that pain point and focus on that and get them to resolve that issue. You see what I'm saying? So we're going to need to do a lot of contract interpretation, and we haven't been doing this yet, but don't forget about the request for qualifications. The RFQ is an instrument for interpreting the PSA.
And why is
Don't
that
forget
so?
that.
Why is this an instrument for the interpretation?
Somebody else.
Based on Article 31 of the Purchase and Service Agreement, it says that the contract should be interpreted with regards to the request for quotation.
Is it with regards to?
Or
Was
in relation. Open it up. In light of?
In light of, right?
Yes.
Isn't that interesting? What does in light of mean? I'm not really sure, but we need to figure out, don't forget that this exists. We've only been dealing with this for a little bit today, but we can try to focus more on some of these other interpretive tricks when we get to respondent tomorrow. So, and you'll be over there too, right,
Yes,
tomorrow? So it's the same group of people. Make sure that we focus on not doing the exact same law analysis for later on.
And we should move to
Let's do
validly.
it.
Was the CSG validly excluded? No. Why? This is how it is sometimes in a classroom. Like, come on, participate. Why it was? How can you exclude the CSG? You have a microphone? Yeah.
Sorry. So it can be validly excluded through explicit or implicit. So
That's the CSG says that.
no, the CSG says that you can derogate or you can opt out of it.
Okay.
Exclude from it, like exactly word verbatim. It says the parties may exclude the application of this convention or subject to Article 12, derogate from or vary from the effect of any of its provisions.
So it would mean that the CSG is saying to us, like, I have to be explicitly excluded. Okay, so it's explicit exclusion is what is the standard. However, because this is what happens in real life, you have these situations where we have to see, was it implicitly excluded? And for that, the commentary tells you there are specific situation. It's not any kind of implicit exclusion, because if that would be allowed, this would open the doors to so many issues, So what is one of the examples how implicitly CSG can be excluded? Where is the, no, Mike?
I think at this point I've memorized them all. So there's non-contracting state, should I say the ones that apply or just all of them? Okay, so for in this case, since they did not use select a law of non-contracting, you can use Article 8 to determine the parties' intentions on if they implicitly excluded the CISG. The specific code of the country, civil code.
Governing law is the law of sales of goods.
Yeah.
Yeah.
By the way, it says choose law displacing CISG.
There's also if they had negotiations or they talked about stuff that fell outside the scope of the CISG. So for example, in our case, there is, I think in Respondent Exhibit 2, is it? Yeah. Respondent Exhibit 3, Ms. Smith discusses assurances and misrepresentations according to the law of Equatoriana. So this actually helps respondents because it's a topic that doesn't even fall within the scope of the CISG. So that is also a recognized method of excluding it.
I would like a more clear standard for that. Someone's got it. Just shout it. What else?
Intent of the parties? Yeah, and obviously intent of the parties.
And one more, if the contract leaves no room for the CISG to govern the contract itself, when the terms of the contract is contradicts and very specific and like leaves no room for the CISG to apply, when every like scope is like determined by the contract, not CISG.
So details and includes provisions that are not in line with the CISG.
Yeah.
One is one that I really like. It's sad that we don't have the whole contract because I'm willing to bet this construction contract has, for every right and obligation that exists in the CISG, has a specific provision about it in real life. A real life construction contract would have that. But that's not what we have. So here we are. But what I want to know is, what is our standard here? These are options. These are methods of doing it. What is our standard that applies to determining whether we've excluded? Can someone pass their microphone? You know, did I steal it from you? God, I hate these things. Okay.
The standard would be choosing a law replacing the CISG.
So choosing is the standard. What is that? How do we know if they've chosen? What I mean by standard is like, for example, the standard of review in court. You review
Yeah.
something de novo if it needs, so you do the entirety of the review, or you have to review things for like strict compliance, right? What is the standard that we need to apply to determine whether these things have occurred, these implicit exclusions? There's a really important couple of words.
Do you mean the intent of the parties?
Right, but how? Yes. So what I'm getting at is, if you look at the CISG advisory opinion, I'm pretty sure it's in the opinion, it says that you have to show that the parties manifested a clear intent to exclude, right? Right, clear and real. So whatever that standard is, know the standard and apply that standard, right? Or find one that's more favorable to you. Important arguments are burdens and burden shifting. What is your burden? Have you met it? And if you have they met theirs, right? So the burden here to determine that you need to meet, or the respondent needs to meet, to validly exclude the CISG is a manifestation of a clear intent to exclude the CISG, right?
What about intent to include the CISG?
What about it? Anybody?
Yeah.
Please.
It's not on. Oh, okay. So, for example, I think it was Joanna Ritter's witness statement, which is R1 in para 11, page 30 of the bundle, you will find that.
Before we get there, do the parties need to manifest any intent for the CISG to apply? That's what you're
There has to
asking,
be an
right?
agreement between both parties that the CISG to
Does
apply.
there?
No.
Yeah, at least has to be one party that
No, right? Why not?
party needs to apply.
So if the case is in the scope of application of CISG, they don't need to explicitly say that they want to CISG to be applied in the matter, and I think they don't need so.
Right, we don't need any intent necessarily for the CISG to apply, right? Because it might apply on its own by virtue of autonomous application in Article 11A, right? The intent is not one of those elements. However, the parties certainly can choose the CISG to apply. They can say, we choose the CISG to apply to our contract. That would be super weird. That's a pretty uncommon choice, but they most certainly can do it. And what standard do we need for that? How would we know if that's been met? Because it's just a regular agreement, right? Just shout out, how do we know party intent? What article? Article 8, right? That's the standards in Article 8 are what we would need to demonstrate whether the parties have chosen that law, right? But for the purposes of exclusion of the CISG, because of the way it's structured and apparently according to this advisory opinion and perhaps case law consistent with it, they have to manifest a clear intent to exclude that law. It's a little bit different than what you would just find in Article 8. So here, when we said if the parties intended to exclude, they may have, but have they manifested that intent clearly to exclude the contract, the application of the CISG? That's what you want to do. And you want to say it's respondent's burden and it's super high, right? You want to shout from the rooftops, manifesting a clear intent. So not they sent an email one time or they have a Moody in their office and they were doing stuff, right? It's not, they have other provisions that are kind of domestic and those kind of things. That's not enough. That's not a clear intent. It's not, you know, we're not looking beyond the text, right? We want to say, look, it's not there. You want to set it up high.
Good point is to make that it was actually Claimant who was always clear on the intent to include the CISG. You know, you have, and I think that's also important to mention, while respondent never clearly showed their intent to, and they would never want to show intent to exclude the CISG. So
I mean, I
they
think
were
there-
not,
Yeah,
they-
there's lots of arguments for respondent here. We're not saying there are none.
Yeah.
What I want you to do though is research and understand that standard. This is what I mean about these arguments. You need to identify and rigorously apply legal rules and legal standards. This is your job for the tribunal. Members of the tribunal, respondent has suggested that the parties have excluded application of the CISG. However, they have not met their very heavy burden to demonstrate a manifest clear intent to exclude the application of the CISG.
So-
Manifest means this, clear means this, right? Then tell them why it has not been manifest and or why it is not clear enough to demonstrate exclusion.
and what is clear and what is to like clearly manifest this intent, it's going to be probably in a commentary with a case law as an example, how it is. And often actually that intent is showing by choosing non-contracting state, you know, choosing the law, displacing the CISG, other stuff talked about, or that's other standard, okay, and complete derogation. Okay, so intent technically as one of the examples how to do it, but actually intent is what this is showing the intent of the parties. So it's like a little bit circular, just, but be like, you have to be specific when you're gonna address this. And you need to tell the tribunal, look, this is how it, if you, the respondent did not show or will not be able to show there was implicit exclusion, because for that it's necessary to, you know, it has to be intent of the parties, or it should be one of these example, and none of this is here.
Did you have a question? Go ahead.
Yeah.
It takes a sec to turn on. Yeah.
So basically, isn't Claimant responsible for the exclusion of the CISG? Because Claimant created the risk pursuant to Article 79, as Mr. Damon has to negotiate by saying that the CISG is the golden standard, but yet Mr. Damon did not, basically Claimant did not further negotiate. And to consider the fact that Mr. Damon has an LLM and
What is the Article 79 risk? What are we talking about here? Or Article 29, sorry, what does it say?
Oh,
Or
you're talking-
what is the risk I'm saying? I thought you were applying an article on the CISG.
yeah, me
Yeah.
too.
Yeah.
Are
so-
you implying, referring to Article 79?
the CISG.
Right, so what is Article 79 of the CISG saying risk that is agreed to in the contract or just risk by any kind of risk, right? Because this is that contract interpretation, does the CISG apply to the rights and obligations of the parties while negotiating the contract, right? Are they creating risk in the negotiations?
Do you want to elaborate more on
Yeah.
your question?
How does that apply?
I would say because under Article 79 of the CISJ, the sphere of risk, which is created by one of the employees of a company, as to consider Mr. Damon as an employee under a claimant,
Mhm.
so he should have like considered the fact that the CISJ does not apply. He should have negotiated more.
Yeah, I'm not sure that that's how that works, right? So the sphere of risks is not, like, there's no risk to the other party, right? There's no risk being created really at all. It's just intent hasn't been manifested. It's not like, for example, they were the ones who were responsible in the performance of their obligations to bring all the trucks on site. And when the trucks explode because they were negligently driven, you can't sue us for the cost of those things. It's within your own sphere of risk, right? Whether the parties are communicating is not the creation of a risk. That's, I wouldn't think under the CISG.
And I feel like
But
is-
there is another rule, right? There's contra preferendum.
Mhm.
That might be applicable, and that might be closer to what you're thinking about. Because in that principle says the risk effectively of an ambiguous interpretation, which is really the risk that's being created by what you're talking about. The risk of an ambiguous interpretation rests upon the drafter, right?
and
That's
what's the drafter?
respondent,
Respondent.
right? So yeah, probably would go the other way.
You have a question?
It takes a sec, yeah.
Okay, so I have a few questions. First of all, contra preferentum wouldn't apply because they did end up negotiating the contract, right? It's whenever the contract has to be read against the drafter, but here the terms of it were not set for claimant to just accept the negotiated aspects of it. So not
I'm not following, sorry.
Where, yeah, the contra preferentum would apply when there's a party drafts a clause and that clause is ambiguous and we can't determine necessarily the conclusion of what it means. You therefore interpret it against the drafter, right? So it's not the entirety, just because two parties agreed to the contract doesn't mean there's no longer a drafter, right? It's a standard form contract drafted by the respondent. So if we do have ambiguity in those standard form clauses, perhaps you could interpret it against the respondent, right? But the termination provision, for example, you probably couldn't. they
Because
agreed to
how
it.
it looks in real life, we meet and we discuss a bunch of stuff, but then it was someone who drafts the version, submits it to other side,
Mhm.
other side gives a comment or something, and then they sign it. That's how contracts will go. Or what Robbie mentioned, those like standardized, contracts where it's like in this model contract that it was, they're using their model standard contract, which they had to discuss some of the aspect, but it was still drafted by the respondent. It is their language and the wording that was put in.
Does anyone think respondent has a good argument on exclusion? Really? I'm surprised so many of you do.
I'm so excited for tomorrow.
Yeah, I'm curious.
What about the VCLT argument?
The
Saying
the Vienna Convention
Yeah,
on treaties.
yeah.
So why would that apply to interpretation of what? What are we interpreting first?
No, like I didn't include in my part, but I received as a claimant our counsel. They was saying that under the VCLT the international treaty should be applied by the states, and they said they cannot. They can.
So
No, they like based their argument saying that Article 2, like international treaties, should be applied by the states.
and why does that not work?
I'm assuming it's because that is meant for like public international law treaties, and this is private international law, so it doesn't bind the state in the same way.
What else? More importantly, what else? Yeah, 100%, 100%. The VCLT could be used. 100%. So why does it not work for the CISG? There's a specific reason why it doesn't work for the CISG.
Because it's private contract between the private entities.
No, are you using it to interpret the contract or the convention?
Okay, so explain to us what do you mean by using the Vienna Convention for interpretation of the CISG?
Well, they base their argument saying that Article 2, the international conventions, should be applied by the states.
Well, okay, so who knows why the CISG is not subject necessarily to that same requirement? What do we need? What does the CISG have different than a lot of other treaties?
Self-executing.
Self-executing, what else? Anybody?
Because it values at its very core party autonomy and it allows the parties to derogate from applying it.
What else? The CISG tells you how to interpret and apply it itself. It is interpreted and applied autonomously inside of the document itself. All over the place, right? All over the place, it says it. Yeah, yeah, right? So the CISG, it's not that it's not subject to the VCLT, it's that the provisions of the CISG itself guide us on that process, and you are properly applying it through that VCLT by using the CISG to do it. You see what I'm saying? The CISG itself tells you how to do it, and to follow that article is to use the CISG to interpret it, even to its exclusion. Would still be that same, but would still work.
Since the CISG is based on party autonomy, shouldn't we interpret the exclusion of the CISG based on the agreement of both parties, even if it's done implicitly? That's what.
What do you notice about all of these? All of them are party intent, right? All of them are. They are just examples, because again, this is the standard that we're applying. This is a manifest, clear intent, or clear and whatever, real intent. This is all about party autonomy. So when similar to what we did before, and we're going to do complex contracts interpretation, understanding the structures that apply within the CISG analysis, here we're going to have to look to what elements reflect the party intent to either to exclude the CISG, and for us, we say it's very little or none, right? They might have some whiffs, inklings, suggestions, a twinkle in their eye about maybe excluding the CISG, but that's not the standard. The standard is the respondent, not the claimant, has to demonstrate that the parties have a manifested clear intent to exclude the CISG. You want to scream that from the rooftops. You want to know every case on it and be able to articulate how that is met and how respondent is woefully below a manifest clear intent.
This is the examples that the commentary gives you. Sorry. This is the examples that the commentary gave you, okay, based on the case law, where what courts or the tribunals have interpreted parties' intent, and they say it was their intent when they chose the non-contracting state to actually exclude the CISG. Okay, so that's why those lines are now showing it.
And don't fall into the trap of our Lord and Savior Ingeborg Spencer said something, therefore it is true, right? This is going to be a big problem for this problem. She's a real smart lady and she's super nice, right? But when we talk tomorrow and we switch sides and we're respondents, now she is a globalist that insists on doing everything she can to apply international law to the exclusion of domestic law. And we, as licensing out our natural resources, wanted to apply domestic law to an infrastructure project in our country, and no witchcraft or whatever else you need to do can get the CISG to apply here. We wanted that excluded by everything that we've done in this contract. Obviously, we wanted the domestic law to apply. That's what we were trying to do, right? Don't take for granted when you've got a list like this that looks good for you, because there's always the implied other option, which is any other way that you can manifest a clear intent to exclude, right? There's a lot more than just that short list for being abortion.
And comment, okay, just commentary, what kind of type of source is that? Primary, secondary? Secondary source, okay? Commentary is done based on what? Usually reading the law, reading the scholarly work, reading the cases. A lot of times cases are not published, okay? A lot of time you only find about the case when it gets to the Supreme Court. This is the unicable to different jurisdiction and many of them, but again, there's difference between German courts, French courts, Italian, American, Brazilian. So again, while Ingeborg Schwenzer, amazing lady, and has provided the commentary that in most parts corresponds to what Kroll, Brunner, and everyone else has written, again, but again, it's just one interpretation of it, okay? Maybe we could, if we start doing a research, maybe we could find, 100 cases saying differently. and then we could write our commentary. So, I mean, we don't plan to do that, but I'm just like, while it's good, and we always, as your coaches, we tell you, check the Schwenzer, check the commentary. Yes, but don't let this stop you from second guessing what they're saying. And also because, again, it's always application of the law to the facts of the case, and the facts of the case are never the same. Okay, so even if you find a case law, check the case, check what was factual there, and you can make conclusions because it's similar, or you can differentiate it. Okay, so that's what you can do, even if you have a case law that says otherwise.
I'm so sorry. I know we're out of time, but we didn't address one thing, and that's the exclusion of conflict of laws. So where do you think that falls into all this? Because I think this is our Roman empires, because we do not.
So conflict of
That's in the other one, right? Because the options that are available to us are choosing the law of a non-contracting state. We're not in that universe. Choosing a law that displaces the CISG. We're not in that universe. Other stuff talked about, who knows what that means, but we might be in that universe. Manifest clear intent, right? All this, so these are all examples of that, but an otherwise demonstrating a manifest clear intent could be there. I think the exclusion of the conflict of laws rules will not on its own be enough, but the exclusion of the conflicts of laws rules in concert with the drafting history of the contract, the changing of the model clause, the negotiation history, they're on and on and on. Respondent's going to be able to paint a picture that says, like, come on, the parties didn't want anything except the equatory on a civil code to apply.
Okay, but we're speaking from Claimant's point of view, so right now I'm focusing on one thing. Okay.
You know those people who you can do 10 million things, but if you like have a stain on your shirt, then all they're going to remember is that stain. Like you're doing a wonderful thing, but you got something on your mouth, and you're like, that guy is disgusting. No matter how smart they were, he had something on his mouth, and that's gross. That's what you want to make this seem like, right? You want to super focus in and say that is not enough. All the cases, all the commentary, everybody says that's not what this is. The CISG applies as a matter of substantive international law, not as a matter of a conflict of law principle. Those conflict of law rules inside of the CISG aren't excluded by these kinds of clauses. These are meant to be an anti-renvoi clause, only when you avoid an actual foreign law being applied, not a treaty that is a matter of the law of that state, right? Just like hound and hound and hound, so that whenever they go to all the other stuff, this is going to be that little piece of felt on their mouth that's like, all the other stuff too, but they didn't do it in their contract. They negotiated that contract, they agreed to it, they sure could have, and they didn't. That's what you really want to harp on.
Yes, so we want to say intent of the parties was not to exclude the CSG, and even if they're trying to argue it was implicit exclusion, it's only possible in this particular way. And here, what the standard you would apply here? Under the interpretation of parties' action statements, we have the intent and Article 8.2, reasonable person test. Would the reasonable person think that excluding the conflict of laws would mean exclusion of the CISG? Okay, we have sufficient information here, and usually what Robbie mentioned, renvoi, that's what you mean by that. Reasonable person would mean excluding the conflict of law rules, principles of your country that would lead us to the situation on renvoi and something else applying. And that's not the case here. The CSG is not that. So reasonable person test, if you apply it here, again helps us as a claimant to say, first of all, this is now how you implicitly exclude the CSG. And the reasonable person test applied here would also show you that there's no way that what the parties wanted, okay?
I think you can also do things like demonstrate that the parties understand how to reflect intent to choose specific laws, right? Because like, for example, respondent in the RFQ cites the very specific statutes for application to very specific things. They've got that skill set and they just don't exercise it here. And members of the tribunal, your job is not to rewrite the contract. Our job is to apply the contract as written, and as written, it applies equatorial law, which includes the CISG, and they have not derogated from that. don't add that clause to the contract itself.
What do you use when you're applying Article 8.1 and 8.2? What do you rely on? You apply Article 8.3, conduct, negotiation, usages, all of that. And here you have so many elements to show using all of those interpretation tools that the convention tells it itself. There's no way we would, under the Article 8.1 or 8.2, get to the exclusion of the CISG. Okay, this is us as a claimant. As a respondent, we will come with some arguments tomorrow. Any other questions that you have? Something that was not discussed? Yes?
Is coffee next? Is that what happens next? Or do they come right here? What time do they come back in here? At 3? Great.
Okay, so you still have some time for coffee.
Yeah, do we want to release them now and then you can talk to us after? Yeah. Okay, yeah. You are released for coffee and come back here at 3 o'clock.